Ready? Ready? Most of the advertisement for our conference indicates that the participants will consider the circumstances under which UN treaty enforcement mechanisms are an essential part of protecting the human rights of average Americans and U.S. residents. Part of the circumstances we're going to consider are addressed by Opt-in USA. And you may have seen reference to that in conference information, the promotional material. Opt-in USA is a grassroots U.S. foreign policy reform, judicial accountability, and international human rights campaign sponsored by our organization, which we call the Law Project. The campaign, Opt-in USA, has produced 3 major reports since 2016. Our 2016 report explains that the Law Project, that the Law Project's focus on the epidemiology of persistent U.S. legal system abuse and corresponding work as a judicial accountability specialist brought it, meaning the Law Project, to spearhead Opt-in USA. In preparing for our conference, that sentence struck me as very significant. Of course, epidemiology is a medical term. Who wants to give a shot at telling us what it means? You have a professional here? Go ahead.
Epidemiology?
Yes.
The study of diseases.
The study of diseases.
I think from what I recall that it studies the origin and progress of epidemics, like typhoid and that sort of thing, the Black Death of the Middle Ages.
Mm-hmm. Yes, diseases. So sometimes massive public diseases, sometimes not. The description I settled on is it's the study of how, why, when, and where diseases occur among people and other animals, as well as ways to prevent and cure these diseases. That's the most comprehensive definition I saw that I like. Because by analogy, the Law Project's focus is on the disease of persistent U.S. legal system abuse. Now, let's start with the presumption that there is no such thing as persistent U.S. legal system abuse. Okay, let's start there. Because a lot of people will. Although we've had organizations with collectively thousands of members attest to this phenomenon of persistent U.S. legal system abuse, let's just presume that we're all crackpots, that this group, my fellow advocates that's saying there's persistent U.S. legal system abuse, let's say we don't know what we're talking about. Now, I'm asking us to do this what if exercise so we can begin considering why the epidemiology of something as serious as persistent U.S. legal system abuse is not common or widely known about. Because, if you're studying, the how, the whys, the when of an alleged disease, you can establish to what extent there are aspects of it that are imagined and which are real. So whether you think it exists or not, just the basic concept of persistent abuse of the legal system is serious enough. Why is that not a household, little kids talking about it? Lil Wayne and persistent U.S. legal system abuse. That's really what I want us to consider. But more seriously, particularly organizations whose missions are consistent with protecting human rights, protecting legal rights. Why is that not a common consideration? But let's go back to the notion that we're just crackpots. What's interesting, I found, and I've been a full-time U.S. legal system reform advocate for 20 years now. I've been working on a national level since about 2002. And because of the internet, I'm talking to people like they're my, lifelong friends. I never met them. They live somewhere across the country. But because of that, I was able to get a very good sense of who's out there, who's claiming to have these problems. And it's interesting that even relatively relatively few advocates who will attest that there is persistent U.S. legal system abuse. They're most I found are unwilling to consider or address that problem beyond chalking it up to deliberate misconduct or corruption among lawyers and judges. You know, we don't need to study it. We know what the problem is. They're all crooks. Okay, and as Shakespeare, a good start is all of them at the bottom of the ocean. Okay, now that's a common sentiment. But we have a somewhat, our debut report, 2016, is somewhat lengthy. And in it, Opt-in USA described a distinct manifestation of persistent U.S. legal system abuse that we call, we documented that manifestation. And a unique strand of it is what we focused on, and we call that the third degree. Now, naturally, a lot of people have read about the report. They haven't necessarily read the report. But what we tried to make clear, and just making people aware that the report exists, is that the third degree involves serious human rights violations, as well as various forms of improper judicial bias, and that this third degree persisted ultimately because of inadequate judicial oversight in America, which we attributed in this report to violations of the ICCPR, and also another treaty that we're not addressing at this conference, the Convention Against Torture and Other Cruel and Unusual Punishment. And then, of course, both of these treaties are stem from the Declaration of Human Rights. So we got that specific. We didn't, just crook scumbags. We talked about specific violations of international human rights law, the involvement of improper judicial bias, and the problem of inadequate judicial oversight in the United States. Now, obviously, these are very serious considerations, and it's only appropriate for someone who's considering it to contemplate whether these are credible allegations. I mean, I would think it's natural. If anyone here doesn't think that it's appropriate to consider whether these are credible allegations, please do not raise your hand. But let me propose that the credibility of Opt-in USA is important because the campaign is advocating that average Americans and U.S. residents need the option of treaty enforcement to protect our human rights. Dr. Tatiana Neroni, who I mentioned earlier, she's went even further in her report, and she says there's no protection of human rights for Americans within the United States. So I'll share it again with you. I'll pass out after my presentation the table of contents for her report. When you're talking about the lack and the vulnerability of Americans to human rights violations perpetrated by our own government and involving the U.S. legal system, I know a plastic surgeon that I was interacting with. That was the first time I heard it described as a weaponizing of the legal system. Those are serious considerations. So, this is a wonderful audience. I'm happy to see you all here, but why aren't there, people from a lot of different organizations, major human rights organizations, law reform organizations, lawyers, public defenders? Why aren't they here to talk about such an important topic? Even if ultimately you don't agree with everything that we've had to say about it. Understanding why we think that U.S. legal system abuse is ultimately attributable to inadequate judicial oversight in our country and violations of the ICCPR, as well as CAT, the Convention Against Torture, and the basic Declaration of Human Rights. You have to take a comprehensive look at that phenomenon, persistent U.S. legal system abuse. You can't just stop at, my problem is this lawyer is crooked, the judge is crooked. If you want to ultimately come to understand that it's about international law violation, human rights violation. Again, this is not a popular undertaking, what we do, and we'll consider why that is the case throughout the day. But for now, let's take a closer look at this thing we call the third degree. The third degree is a national pattern of persecution imposed through U.S. legal system abuse. Now, when you think of persecution, you know, maybe if someone has an example of what they think about when they think about persecution. Does anyone? What do you all think about? Anyone have an example?
Well, historically, we had the Inquisition. That was one form.
Exactly.
And there were others like isolationism and that sort of thing, ostracism. It takes various forms.
Yes, and you know, persecution, it can come in various forms. Go ahead.
Well, no, I think most people view it as physical instead of psychological. And that might be the reason why it's hard for people to comprehend some of the issues, because there's a lot of psychological aspects to it compared to physical. You know, whenever we look at history, we see that, you know, there's actually a big scene force that goes and does something to people, you know, physically, but it's been turned into a more psychological aspect, and since you can't see it, it may or may not exist.
That's interesting. So it doesn't seem that anyone is thinking of persecution any way other than on a global scale. I mean, because persecution could be like Mrs. Roach, you know, trying to, you know, constantly getting at me, telling me not to put the forks in the sink, in the dishwater before I rinse them. That's persecution. But we're talking about in a global sense, in the sense of government. You know,
most people probably think World War II, you know, that kind of aspect, they think it's, you know.
Well, what it is when I first started considering the concept of persecution in relationship to U.S. legal system abuse, it really, I went to the case law on immigrants who were applying for political asylum in this country. And I started looking at, they were saying that they were being persecuted, and what type of allegations tended to get them, you know, asylum, and which type didn't. And so that was the sense in which we were contemplating persecution, something that would get you political asylum. You know, that you are, your quality of life, your life is such a threat in your own country by your government or rogue agents of your government, that you need, in order to protect yourself, you have to leave the country. We have a speaker today who's living in Latin America. She contends because of that very same thing. She had to leave this country because she was being persecuted because of her allegations of various forms of guardianship and probate court abuse. Well, often, I want to make clear that our 2017 and 2018 report acknowledged for the first time, that wasn't quite clear that there's such a thing as episodic U.S. legal system abuse and persistent U.S. legal system abuse. A single episode of U.S. legal system abuse can be so debilitating that a target of the offense never musters the wherewithal to pursue any seemingly viable avenue of relief. So we were initially more focused on what happens to you if you put up a fight. And again, when I talk about advocates, that's not NGOs, that's just, you know, refusing to accept a plea and demanding that you go to trial, you know, refusing to continue to fight for your children if you're not being able to have adequate interaction with them because of a high conflict dissolution proceeding. And you experience this abuse of the system, which I'll give some indication of what type of abuse we're talking about. But You know, I thought that perhaps people didn't perceive themselves as persecuted when you go from one court to another and you get you're not receiving fair and impartial resolutions of your claim. I get the relief that you're seeking, but you know, we were seeing people who had pretty compelling evidence that whoever was resolving their case wasn't fair and seemed to favor someone else other than them. So I thought perhaps that people, when they were in the midst of getting railroaded for a crime they didn't commit, or you know, not being able to back off the aggressive, unethical business partner who's taken over the business, I thought that a problem was people didn't see that in terms of persecution. So other than the physical versus psychological, is there anything else that you think may keep people from relating their personal legal difficulties to these international concepts? It doesn't have to be, I'm just asking.
Well, a lot of times it's, you know, when somebody's actually in a fight, you know, the things that happen tend to be unbelievable. And because of that aspect, it's hard to, you know, get others to relate and say, okay, well, we know we live in America, we know we have all these laws, we know that, you know, there's due process, we know that all these things exist in theory, but when they're applied and they don't exist there, it's hard for others who haven't been through similar circumstances to actually believe you. You know, just like there was something I saw online that, you know, it was actually in reference to child custody.
Yes.
You know, and the child gets taken away, and which in turn makes the parent upset, and then next thing you know, the court's like, oh, you're upset, there's something wrong, let's get them a psychological evaluation. It seems like, you know, these things that don't necessarily need to be put into play automatically get put into play to frustrate, and when you try to explain this to people, you know, even on a local basis, they're like, well, that's not really believable, despite the fact that it did transpire.
And I have something even that you wouldn't even think happening in America. My husband is Irish. My husband can't even live here right now. My husband is Irish. We've been married almost 20 years. What would it take? Why can't my husband live in the United States? Because his wife is here. I can't. We have a struggle. And this is one of the unbelievable things in America. You should, if you're married to someone, you know, that's the thing that they're talking about. You can't get married. You know, they try to make sure you're not trying to make somebody get married so that they can get into the country. This is Ireland we're talking about, which is a sovereign, and Ireland is part in alliance with the United States, and yet my husband cannot be in the United States anytime he wants. He can only be here 3 months.
Well, what
3 months.
happens is, because when I started having my conflict with the legal system, you know, of course, some of my closest friends were lawyers, and it's not that people have no conception of corruption, misconduct, but our system has so many levels, avenues of relief, that by the time you've gone from one judge to another, one appeal to another, one prosecutor to another, one member of Congress, one legislator to another, people start thinking, you must be doing something wrong. You know, there must not be anything to your claims, or maybe you need a lawyer, maybe you need a better lawyer, something. If you had something to your claim, surely by now they would have brought that out. So that is what we're dealing with. And also one of the challenges is that most often the people you're challenging are very esteemed, you know, pillars of the community. You are the person that lost your job. You are the person that lost custody. You are the person who got disbarred.
Credibility.
You know, and then your finances are compromised because you lost a job, and so it makes it you know, a self-fulfilling prophecy. Now, so we have this episodes of legal system abuse, as opposed to persistent legal abuse. Now, some of this may happen no matter which of the two it is, but targets of the third degree are they invariably have one or more of these 5 things happen to them. They are disparaged and discredited through legal process. You know, in the rulings, they get personal, and they say things like you're unprofessional, or you know, they start, you know, you start saying things that are more a reflection of you as an individual as opposed to the facts and law of your case. There are activists who report being intimidated for their activism through violence or threats of violence You're denied the equal protection of law and corresponding access to courts. So you go to court, and it's such a vain process that you might as well have never have started. Or if you're not outright denied the ability to file papers in court on the grounds that you're a vexatious litigant. That was a real popular term a few years back, where they're saying that you can't accept the loss, you keep refiling. You are impoverished through questionable job losses. You have unwarranted blacklisting, questionable imposition of or denial of fines, sanctions, or damages awards. So you either have them imposed on you, or when you're trying to get them on someone else, you can't get them. And you may be incarcerated under questionable circumstances, particularly pursuant to contempt proceeding. Now, one or more of these 5 incidents happen invariably to people who are the target of the third degree. Now, with very limited exceptions, any claim that a target of the third degree pursues or defends against in court imposes on him a variety of 7 different forms of legal system abuse, 7 different detriments. You may experience procedural irregularities, such as you're not allowed to have a hearing. I've heard of people having substantial rights denied them, and they never had a hearing. The other thing that's very common is untimely notice. I've heard of people who got notice of an order that they had to appeal within a certain amount of time. They got notice of the order after the time for appeal had passed. You have evidence tampering, that can happen. People have talked about transcripts, even recordings being altered or destroyed. Another thing, that's all part of procedural irregularities. Another thing that happens is you have questionable departures from well-established precedent. So you have something that, you know, when you go into court, your representative looks and says, well, what are my rights, what are my obligations? It looks like I have a legal claim because of this law. And it may even be well-established for years. Oh yes, you have this right, you have this right. Well, you go into court and all of a sudden you don't have a right. You have undisclosed grounds for adverse credibility determinations. They just don't believe you. They don't come in and say, well, you know, Zena, after the 7th perjury conviction, you know, we just don't find you credible. Now, it's none of that. Or the psychiatrist says you're a pathological liar. No, it's just, we don't believe you. So undisclosed grounds for adverse credibility determination. Rulings that have personal character disparagement, that's a goal, and that's also one of the ways that the system is abused. They use the judicial rulings to talk about you personally. You have judicial activism, or that's an arguable usurpation of legislative powers. So you have a court deciding that this is illegal what you did, or it's not illegal what you're alleging, when there's no case law documented, that's just the judge's opinion. So that type of activism. Then you have this thing that's a functional equivalent of ex post facto law. And it's very clear in our Constitution that no legislature can punish anyone for an alleged crime that wasn't a crime when they engaged in that activity. So if I you know, you walked outside with a bandana on, I can't be prosecuted for that unless when I stepped outside, I mean, unless before I did it, it was already a crime. You can't come in and say, you have that bandana and we're just gonna, you know, you're gonna have to do 30 days in jail because it's just horrible the way you look at that bandana. It's a crime. That's an ex post facto law. Probably could come up with a better example, but hopefully you get the gist. And then they have this thing called judicial engineering, and that's a very rare form of judicial misconduct, or a hard to understand form of judicial misconduct, because Dr. Jackson is a historian, so he's aware of cases that are like hundreds of years old, where they made a decision that this is improper. I can't think of an example offhand, but they made a decision a judge shall not do that. And what happens in the law is everybody comes to know it, that it's just taboo. And so you don't get one decision after another every year proclaiming that, you just come to know it. But what happens is, when a judge does in fact, you know, commit that offense, then it's hard to find case law that you know it's wrong, but you can't find any cases that specifically declare it's wrong. And so there you are arguing that it's wrong, but you can't find any cases to back you up, and you don't have any persuasion with the court. Now, can we get to the end? Okay, so those are the 5 specific goals of the 3rd degree, that particular form of U.S. legal system abuse, and the strategies that are used to accomplish those goals. There's 7 specific strategies. No, not 8, not 9, 7 specific strategies that are used to accomplish that form of abuse. Now, before I get into who tends to find himself or herself on the receiving end of persistent legal system abuse, let me emphasize that Optin USA doesn't vouch that the 3rd degree has happened in any particular case. You know, no matter, we don't, you know, we're not saying that anyone is alleging this abuse has in fact experienced it. We see plenty of compelling evidence that suggests it, and we're prepared to make that confirmation. But our bone of contention is primarily that when these offenses are alleged, it appears that receiving a fair and impartial consideration of those allegations, that just doesn't happen. In fact, the more persistent you are at complaining and saying that the legal system is weaponized against you, that is not a fair and impartial adjudication, you're trying to punish me. There's a scheme to this. The more you persist in that, the more you get subjected to the same pattern of behavior. That the value. So what is the value of our identifying a pattern? This is the same pattern across the country, and it happens. Hopefully, you're remembering that we're talking about judicial bias. These type of abuses of court can happen if the judge is not somehow facilitating it, because ultimately the judiciary is the gatekeepers of the legal system. So if the system is being abused in any type of way, is ultimately the judge's responsibility. But what happens in the cases that we're talking about, the judges don't stop it, and in some ways, in a very positive way, in a very aggressive way, helps make it happen. So, you know, there's a value in identifying this pattern. Because remember, I said I've been doing this for nearly 20 years. We first identified this pattern in 2016. We had been complaining about, you know, we weren't getting a fair break. It didn't seem to make any difference what your credentials were, how sophisticated you were in presenting your claim, how unsophisticated. When it just seems like these powerful people, including government actors and public officials, were aligning against you to punish you for being a critic of the system or being persistent with your legal rights. that's what we were talking about. That's what we complained to the United Nations in 2010. And we had a stellar coalition of advocates. I mean, we had very accomplished public interest attorneys, very well regarded constitutional law experts, some of the most productive grassroots legal system reform advocates in the country. One of the people who we based our report on has gone on to be the chair of the ABA Ethics Committee. And all we were saying is that when these rogue agents of government align themselves to against you, it doesn't seem to matter what you do, and you spend years, sometimes decades, trying to get relief, through political systems, create public awareness, protests, costly, complex litigation, and seemingly get nowhere. So the point that we were making to the United Nations in 2010, because they were looking at whether the United States respected human rights, and we said, this is not due process. This is not due process. And we recognize that when you have a legal difficulty that has implications beyond you, and it reflects a larger community, that your legislator's got a lot of people, a lot of constituents. Sometimes you have to get political. Sometimes you have to form groups to show that this problem impacts a wide variety of people. It has serious implications. It's not just you. And we should be prepared to do that. We simply have to recognize that there's limited time, there's limited resources, there's limited manpower. But we're rarely welcome through major media. We found that major media will consider individual action by a judge. This judge got a DUI. This judge, got in trouble for sexual harassment. But when you start critiquing the entire legal system, to try to get major media coverage, didn't seem to happen. Then that's when we were saying that having your rights have become more like privileges, and so we made that representation in 2010. Well, with that stellar presentation, that stellar coalition, the system proceeded to, that the same type of questionable conduct persisted, and even it generated a pattern. It started aligning a pattern. So, the point of, the benefit of having this pattern is it creates this handy checklist. Because we're prepared to say, if you don't have these criteria, you're not experiencing the third degree. That doesn't mean you're not having some type of bad, legal experience, but it's not the type of persecution that we're talking about, or serious human rights violations that we're talking about. Meet this criteria, and you have the third degree. Don't meet the criteria, and you don't have it. So, how hard could it be to get that fairly applied? Because I don't care how much I've been saying I'm the victim of it. If I can't produce compelling evidence to show this offense, I'm out. Trying to get that fair and impartial consideration has pretty much proven impossible. And I'll explain a bit about that. But now I want to focus again on our conference topic. Because in talking about legal system abuse, that's the problem that we are saying ultimately relates to ICC PR violation. But this is not a conference about legal system abuse. People will be talking about other subjects, homelessness, trafficking. So I just want to make that clear. Now, with regard to our constituents, let me see, what is it? 1, 2, 3, 4, 5, 6. There were 6 articles of the ICCPR that we identified that was being violated because we were unable to get a fair and impartial consideration of our allegations that one of the ways we describe the third degree is an adjudication is not the goal. It's what the goal is to have you be subjected to a job loss, to punish you. to deny you wealth. And so you only, it looks like you're part of a legal process, but that's not really what you're there for. And we had gone for, at that point, years, and we're not able to get any relief. So we were saying that at this point, there was a violation of this international treaty. And what it is Article 2, Section 3A and Section 3B of the ICCPR says this: each state party, each nation, to the President Covenant undertakes to ensure, subsection A, to ensure that any person whose rights or freedoms, as herein recognized, are violated, shall have an effective remedy, notwithstanding that the violation has been committed by persons acting in an official capacity. Section B, to ensure, the countries that are agreeing to this, they will have to ensure that any person claiming such a remedy shall have his right thereto determined by competent judicial, administrative, or legislative authorities, or by any other competent authority provided for by the legal system of the state, and to develop the possibilities of judicial remedy. So the other sections, the other articles and article sections that we cited just reinforce that notion, maybe had a more particularized context, but that's what they pledged. This treaty doesn't try to tell a country how, what rights to give its citizens, but through this treaty, we pledge that if you're subjected to abuse, even by a government official, we guarantee you, the United States says, we guarantee you, pursuant to this treaty, that you will be able to have an effective remedy. You will be able to go to a competent somewhere and get a fair and impartial remedy. And instead, we were getting a runaround. The name of our 2016 report, we called it a shell game. That people were literally not living long enough for this, relief that was, always dangling right in front of us. Try this appeal, try this letter, try this protest. And finally it had gone on long enough where we said, this is not effective. That's a big part of our going international. That language, we have tremendous rights through our U.S. constitutions, through various federal laws, through our state constitutions, through various state laws. But what layers on top of that with the ICCPR, and if I'm not mistaken, and Dr. Jackson, correct me if I'm wrong, nowhere in any of our domestic law does this concept, it's implicit, but through this treaty they explicitly say, yeah, and all that stuff is nice, but make sure it's effective. Not this shell game, not the runaround, not people just, spinning their wheels, not even living long enough to ever get relief. Now, the last part of my discussion, and I'm not sure what's happening with the time, because Mr. Scott is going to be joining me, but I'm going to outline for you why that is the case. What we have established with Opt-in USA is that there are specific gaps, structural gaps in our legal system that allow it to be selectively enforced. I've been monitoring since about 2010, and when there are countries that criticize the United States, oh, you all have human rights, you need more protection, you ought to let us come in and monitor, have an international body housed in the United States. And the assurance that I've seen is, look, we recognize, the United States takes a position, we recognize we're not perfect, but you can't get anything better than our legal system. It's the gold standard. Our people don't need anything better than what they have. Now, that doesn't mean that we have perfect justice or that anybody's promised perfect justice, but if you're going to get, what you're entitled to, you can get what you're entitled to, but if you're going to get what you're entitled to, it's through the U.S. legal system. And what we documented is that there were specific avoidable structural gaps in our legal system that allowed it to be selectively enforced. In other words, our legal system is the gold standard. It's an absolutely wonderful legal system. It's a awesome mechanism for protecting rights. But if you, for some reason, marry the wrong person and want to get a divorce, marry some powerful business person and quit and only have been a homekeeper. I mean, a house, not been in circles of influence yourself. Be in business with someone who had more political influence and more money than you. Whatever might get you in that path. Try to tell the truth on your job and it's be something that powerful people don't want to have happen. Then the system can be structured such that it won't protect you. Okay, and let me give you quickly, and then I'm gonna wrap up what those structural gaps are. One of the structural gaps is the fact that on the state level, we have in most U.S. states judicial self-policing. Okay, so they discipline themselves. So if you want to allege that the judge did his job, was not violated some rule of ethics in doing his job, you go back to judges. And if you go to a prosecutor, you go to a lawyer whose career is substantially impacted by judges. A judge can shape whether you have a good winning record as a prosecutor or a record of losing. Not to mention that a judge can discipline any lawyer, whether that lawyer is a prosecutor, a private lawyer, or a legislator. So either, and also judges impact even presidents, even executive governors, because even legislators, you can enact a piece of legislation and the judge can determine that it's unconstitutional and strike you down. President Trump seems to be having a hard time with judges. Okay, so what happens is you either when you're saying that the judge acts improperly, you're either going back to judges or people who are beholden to judges. And we're not contending that judges are, just incapable of honesty. You can't trust them to have that much power. What our organization, Opt-in USA, is saying is that that's too much power concentrated in the hands of a single unelected group of Americans. We don't care if they're Stepford judges. I mean, they're incapable of corruption. They're incapable of operating in anything but good faith. I mean, you're just physically and emotionally incapable of it. We're saying in the United States, in a free country, you don't concentrate that much power in the hands of any group, any single group. And so that is the problem. And then also, we take the position that the ultimate check on power, because power corrupts, is citizen oversight. And so what we're contending is there needs to be more opportunities for direct citizen oversight of judges. But judges, just like Chief Weiberg can attest, even law enforcement, they always feel like, you hear them say, only other judges know. And if we had other people judging us, they'd be fighting against us all the time because they don't understand what we have to take into consideration. Well, you have juries who are making complex determinations on a wide variety of legal matters, but somehow we can't make a decision whether a judge did his job ethically when the proper standards are identified and the facts are set out for us. So that's one big problem, is that we have too much power invested in this one group. They're essentially the final arbiter of their own integrity. Another structural problem is that in the United States, how do you measure the extent of judicial misconduct? What happens is when the judicial system, there's a lot of public outcry, people seem to be discontent. What happens? They don't call me and say, Zena, what do you think? They don't call people who are using the system and have concerns about whether it's fair and impartial. Most times we may get a limited time to send in a written critique or 3 minutes to talk at a public hearing. But what happens is you have these judges come together and court personnel and law professors who are historically known for being satisfied with the status quo, and that's who comes back with the report that says, oh, everything's fine. Okay, we had a couple of bad, decisions, but we fixed it, so everything's fine. So our question is, how can if the measurement of judicial misconduct in America gets left to people who seem convinced, and when they start the evaluation, they seem convinced in advance that judicial misconduct is not at an alarming rate in America. How can that view be challenged if anyone and everyone inclined to do that are avoided? We're not brought to the table, or we're otherwise disregarded. So that's a big problem, how we even go about considering whether there's judicial misconduct. Another problem is access to legal representation. We all know about the cost of it. Another, it's unaffordable to most people. Even wealthy people, it staggers me the way they can rack up millions of dollars in legal expense so quickly. Then, when you have the lawyers that are willing to work for little or nothing, and who are conscientious and will take the controversial cases, there is rampant discipline of those type of judges. We tend to become, it seems like a target, and that has to do a lot with some problems with the way lawyers are disciplined in the United States. There's some constitutional issues in that regard. And it's, so what ends up happening is, and this is not just some subjective view of mine. Lawyers who are critical of the government, particularly the judiciaries, soon find themselves escorted out of the profession. So that complicates people's access to legal representation. Not to mention the fact that there's some problems with the legal system when you're attempting to represent yourself without a lawyer. So some real problems. And there's also advocacy out there as to whether you should have to have a licensed lawyer represent you. So these are structural defects. Another thing that happens is all these immunities that you were talking about earlier. Immunities. Basically, it's different forms of immunity, and immunities and unfettered discretion. That's what I'm trying to get to. So you go to a prosecutor, and a prosecutor can decide whether they want to, you may have perfect evidence of a crime, but a prosecutor has unfettered discretion as to whether they want to prosecute. So that's these gaps are not necessary. I'm not necessarily saying that they're bad. What I'm saying is they just form a hole. And that hole is what you can fall through when you're attempting to get relief. You no matter what your evidence is, you go to a prosecutor, and if you're not dealing with someone who's immune, the prosecutor just says, no, we're not going to take the case. Let me see. What ends up happening is you have a community. Another thing is pleading standards. They've made it very difficult to bring these legal claims against courts through federal judicial rulings. The threshold of alleging judicial misconduct is very high, and arguably I published a law review article that contended that it was impossible to reach that order. And the result, and this is my segue into the presentation by my co-presenter, is we have a community of people, it's called being polychronic community of people. And that's courtesy of the financial, social, and emotional devastation that's heaped on them through persistent U.S. legal system abuse. And it literally leaves them with little to no resilience for the monochronic task of effective legal system reform advocacy. And I'm not just trying to use 75-cent words. what happens is, we have a community of people that they just, a lot of times only have the resilience to have a protest. You know, emotional venting, that like Chief Weiberg was talking about. That's all we can manage, you know, sign a petition. I can do that, okay? But when you start talking about graduated advocacy, build databases, you know, campaign, you know, canvas neighborhoods, you know, hand out flyers, and these different things that actually do lead to reform, can be effective. You're left with people who don't have the wherewithal to do it anymore. They just, I had a colleague talk about, you know, he got so many bad legal rulings that he got to the point he couldn't even open his mail. Just getting the mailman came was triggered his PTSD. And then you lost your job, you know, your family, your friends, you're shunning you. So it's a perfect storm that leads to an action and ineffectiveness, and it has reached a human rights crisis that's deadly. And that's what my colleague Ira Scott is going to be talking about. So I'm going to turn it over to him. Let me see what's happening, because he's coming to us online out of New York.